Okay, thank you very much for being here. I know some of you already got a dose of law earlier today at the education law section. This is going to be something a little bit different. My focus is going to be on the Americans with Disabilities Act. My name is Matthew Cavedon. I'm a member at large on the board of directors for AMCSI. I also consider Atlanta one of my hometowns here. I teach at Emory Law School here in town, which is where I am a proud alumnus. So I do not teach disability law. I will get that out at the start. I am a mostly criminal law guy. However, I do have a good sense of law and would be happy to talk through this. If I don't know the answer to any brilliant questions, I will find somebody who does know the answer and get back to you later on. Without further ado, though, the Americans with Disabilities Act. This is our Civil Rights Act. This grew out of advocacy by people with disabilities like Justin Dart, whose quote is up there. It has been federal law for almost my entire life since the early 1990s, and it is the cornerstone of a lot of our access to public life. But what are its specific provisions? What does it mean? What does it actually do for you? That's what we're going to talk about. I want to talk about the different pieces or titles of the ADA, the Americans with Disabilities Act. Title I covers your employment rights. It protects qualified applicants and employees with a disability from discrimination. Title II concerns public services, programs, and activities, and says that if a government is running some kind of a program, it has to be accessible. Title III concerns public accommodations or buildings, businesses, things like that. Your right to actually access those, get inside them, understand the information that they have, use those facilities. Title IV we will not talk about. It concerns telecommunication services like closed captioning, TDD, and internet relay services. Obviously, needs for those can exist together with arthrogryposis, but arthrogryposis itself does not necessarily cause disabilities that would require those kinds of services. Lastly is Title V, which is usually about legal procedures for how you can enforce your rights under the ADA. We're not going to talk a ton about those today either, because those are the kinds of things that probably you would need a lawyer's involvement to get too heavily into. The ADA and accessibility, but first I want to, the ADA and accessibility, that's actually out of order, so I'm going to skip over that one. Employment. The Americans with Disabilities Act says that a covered entity shall not discriminate against a qualified individual with a disability. I pause in all those places because every chunk of that is something that lawyers debate the meaning of and that have special definitions within them. First, a covered entity. A covered entity is an employer with at least 15 employees that is engaged in interstate commerce. So, if you are working for your uncle over the summer repairing cars, and you are the only employee, you have no rights under the ADA. Unless he has 15 employees, you're not covered, you have no protections. Does anybody here work in a place with fewer than 15 employees? Okay, there you go. Then you probably enjoy some rights under the ADA. Yes, real quick. I'm going to take more questions and answers later, but go ahead. For Uber, the company Uber has more than 15 employees. Well,
even though you're considered independent contractors.
They would argue that that's independent contractors. That's a very good question. I don't know exactly off the top of my head where Uber fits. I do know that for some purposes, drivers have been counted as employees and for others as contractors. You may want to talk to an attorney. I don't know if anybody has had a lawsuit with them arguing about their drivers and whether they count under the ADA. A covered entity. They also have to be engaged in interstate commerce. Legally speaking, that tends to mean most economic activity. If they're a business that's open to the public, for retail, for food service, transportation, any of that, they are going to be engaged in interstate commerce, even if it's just one small location in Iowa or something like that.
Doctor's offices, dentists?
Doctor's offices, dentists, businesses that are holding themselves out to the public generally affect interstate commerce, and so the Supreme Court has said that that's good enough for you to have protections under them, even if it doesn't feel all that commercial. The only exceptions might be if you have somebody who rents out their apartment every now and again. I'm not even sure that would fall outside of it. You are probably engaged in interstate commerce if you have something to do with money. So if you're employing people, you are probably covered if you have 15 employees or more. Okay, a covered entity shall not discriminate. Well, what does discrimination mean? Usually an adverse employment action. That's a big, goofy Latin way of saying things you probably already know about. What are some adverse employment actions, people? What are bad things your boss can do to you as an employee? Anybody?
They can fire you.
They can fire you. Hey, that's a really big one. What are some other things they can do?
Refuse to promote you.
Refuse to promote you. Good. How about reassigning you to podunk middle of absolute nowhere when you live in New York City? That could count as an adverse employment action. Changing your hours. That's great. You can work the 1 a.m. to 9 a.m. shift, even though you've always worked from 9 to 5 and you have kids. That could be an adverse employment action. Some of the things the law considers: limiting or classifying a job applicant or an employee in an adverse way. So we need people to answer customer service phones. They need to be able to lift 30 pounds or more. No, that would be a classification. That would be an adverse action. That would be legally suspect. Denying employment opportunities to people who truly qualify. If the job has what is called a bona fide qualification, they can restrict it based on disability. The United States Marine Corps does not need to accept me as an infantryman, okay, because there are bona fide, legitimate physical qualifications for that job. I am not entitled to go work for Major League Baseball as an athlete on the field, right? Nevertheless, they have to be bona fide, which means good faith. So again, 30 pounds lifting requirement for clerical work, you will actually see that in a lot of job descriptions. They're probably usually illegal if they are used to prevent you from getting a job. Warehouse worker for Amazon? Okay, bona fide job qualification, right? Hostess at a restaurant? Probably not a bona fide job qualification. So keep your eyes out for those. That can be a form of illegal disability discrimination. Refusing to make reasonable accommodations based on known physical or mental limitations. We're going to talk more about reasonable accommodations in a little bit. But if they fail to make a reasonable accommodation for an employee, they are probably violating the law. And not advancing employees with disabilities within the business, not providing needed accommodations and training materials or policies, or the provision of qualified readers or interpreters if those are needed. So if you have somebody who needs ASL, that often is a required accommodation. Was anybody in our session with the co-ed group yesterday where we learned about an alternative way to get CPR certification if your hands aren't strong enough? I see a couple hands going up. Caleb, what is an alternative way to do that training if you can't use your hands to do CPR?
You can use your feet.
You can actually use your feet. We found that out yesterday from somebody whose job had her do CPR with her feet and gave her the certification. So be on the lookout for those kinds of accommodations. All right, Title I, employment. I'll talk more about what counts as a reasonable accommodation in a few minutes. Are we okay on employment before I move on to the next topic? And again, there will be general questions and answers later. Next up, Title II, government buildings and services. Title II applies to anything, any activity, program, service that a public entity offers. That means state, local government, legislative branches, executive agencies, judicial branches, your post office, the courts, jail, prisons. Now seriously, they are required to provide accommodations under the ADA. And it's not just buildings, it's also programs and activities. So if your government is going to have a job training seminar or webinar, they have to provide accommodations that make that accessible, including closed captioning, a physically accessible location, and non-discrimination for people with disabilities. All government activities are covered even if it's a contractor who's doing it. So if the government hires some program to do drug rehab, if they are being subsidized by the government to do that, they are covered by Title II of the Americans with Disabilities Act. A public entity does not, though, have to make any fundamental alterations in the nature of their programs or activities. So, State College has a Division I football team. Anybody here from Georgia? Right here, UGA Bulldogs? Okay. The UGA football program is not physically accessible to me in a wheelchair. In order to make the actual football team and its games accessible, not going and watching them in the stands, but playing, they would have to fundamentally alter the game of football. Right? That's not to say that they can't have a disability football program as well, but they are not required to fundamentally alter the program itself. So if you had a government skydiving program, they don't need to necessarily change that to accommodate ventilators if that would mean a fundamental alteration in the program itself. Governments also do not need to have undue financial or administrative burdens around a program. So if I could participate in a public program, I'm trying to think of a good example off the top of my head. Let's say that I was unfortunate enough to be incarcerated, and in order for me to get, trying to think of a good example that would pose a truly an undue cost burden alone, a lot of these would fit into physical changes to a building, which we're going to talk about in Title III in just a minute. There could be occasions where hiring, say, an ASL interpreter for a program that only has 3 people or something might be an undue burden. You would have to have an argument between lawyers as to whether or not it was truly undue. But shy of physical accommodations, a lot of things are not going to be unreasonably expensive for a government program. You can sue the government if it is failing to uphold its obligations. You would need to prove that you are a qualified individual with a disability. Somebody who was in the education talk earlier, what are some ways legally that you show that you have a disability for legal purposes? Anybody? Anybody here in the education law talk earlier? Okay. Well, you've already gotten picked on once or twice here, so I'll let you off the hook this time around. What you generally need to show is that you have a temporary or permanent, physical or mental condition that affects one or more activities of daily living. What are some activities of daily living? Bathing, that's one. Common sense here, folks. What are some other activities of daily living? Okay, all at once, but I think you get the gist here. Reading, writing, bathing, using the bathroom, walking, breathing. If you cannot do that in the same way that an average member of the community would, because of some condition, you are generally going to be qualified as a disabled individual under the Americans with Disabilities Act. If you are going to bring a lawsuit, you would also need to show, hey, I'm disabled, step 1. Step 2, I was discriminated against, so I was excluded from some program or denied the benefits of some public program. And 3, the reason why is because of my disability. So it's not just I am in a wheelchair, you did not allow me to attend public school, and the reason is because I set most of the hallways on fire. No. Step 3, the connection has to be you are denied because of your disability in some way. Okay, Title II, government programs. Are we clear enough on that for now? Yes?
Are roads and sidewalks considered federal? I know they're not buildings, but like, how are roads and sidewalks and curb cuts, what are those covered under?
That is going to fit under, I think, generally Title III as a public accommodation. Usually that means a business. It might also be Title II as well because it is some provision provided by the government. Doesn't matter whether it's local government, federal government, any of that's covered by Title II. Nevertheless, there are special rules that govern accessibility of sidewalks, roads, things like that. So let's talk about physical infrastructure, public accommodations. This is Title III. This might be the one you're most familiar with. Public accommodations, again, most businesses holding themselves out to the public. They're going to be covered under Title I for employment. They're also going to be covered for Title III for customers, for folks who need to get in there and access, for patrons, for folks like that. Commercial facilities, non-residential facilities, office buildings, factories, warehouses, buildings like that, as well as public accommodations offering certain examinations and courses around educational and occupational certification. So private educational institutions, I don't know about you all, I've had to take some certification exams for the bar exam and whatnot in other facilities, maybe a convention center or actually in an office park near us for some professional licensing. You go and you get your fingerprints done. All of that is covered by Title III. What does Title III not cover? Two main categories. One, religious organization property. So places of worship are actually not covered by Title III. A number of religious organizations have their own policies around accessibility, but they're not covered by the Americans with Disabilities Act. In addition, private clubs that do not open their facilities to the general public. So if you've got a golf course nearby, but hey, once a month the clubhouse is open and you can go there for lunch or dinner, that is a public accommodation. If it is truly members only, or you've got an apartment complex and they've got the pool and the clubhouse, but it's only for residents, that may not cover, actually that wouldn't count as a private club. That's a bad example. If you have a private housing estate maybe, where truly you have to pay fees, that's not going to be covered under Title III. Yes?
Will private schools be considered private clubs?
No, private schools are not private clubs. Private schools are going to be considered public accommodations. They're out there, they're open for public applicants. It would be truly a private club, like in your town you might have, say, a Freemasons bar or something along those lines. VFW might count as a private location. The closer they get to business, the more that they blur that line. So your Junior Chamber of Commerce, your JCs, they are probably a public accommodation because they offer job networking, they offer classes you can take. That starts to push the line over toward this is probably a public accommodation. There was a U.S. Supreme Court case that held the JCs in particular actually are covered by a lot of non-discrimination law. It wasn't an ADA case, but that was the question. And the Supreme Court held that they were actually a public accommodation, not a private club. Even though it's members only, they have tens of thousands of members. They offer classes. It's totally anonymous. I mean, anybody can join it as long as you qualify. So that tends to push it over into, okay, this is public now. Yes?
What about historical buildings?
Let's get to that in a second. Being a historical building does not necessarily mean you're not a public accommodation. You can be a public accommodation and be a historical building. But all that I have said so far is what Title III covers, not what it requires. And that's where we're going to get into the messy stuff. Title III public accommodations. There are three areas of obligations for facilities under Title III. Number one, they have to give an equal opportunity to participate. So you have to be able to shop or dine or go in there or sit through classes or whatever inside of a Title III facility as anybody without a disability. They can't discriminate on based against you based on your disability. So before we even get to physical changes and physical access to the building, I mean, this is not so common nowadays, but some of the older folks in the room may remember fancier restaurants saying, hey, we just don't appreciate you being in here. That is illegal under that prong. That would violate your equal opportunity to participate. Number 2, you are entitled to effective communication. So depending on the nature of what it is, if it is a store, well, if all the prices are written, that's going to satisfy their obligation to someone who is hearing impaired. If it is a school, they might have to hire interpreters to communicate the lessons that are being provided. Right? If you go to a concert or to a stadium, they may need to have the hearing loop or something along those lines for effective communication. I won't go into too much more detail about communication because with arthrogryposis, although again that can be connected, it's not really at the core of what makes arthrogryposis arthrogryposis. Third, okay, this is the biggie, right? Providing accessibility. They have to do 3 things. They have to remove barriers. So if you've got a grand staircase into the building, you might need to take that down. Number 2, provide alternatives, if not. So like here, right, you've got a ramp alongside the stairs. It's not that you can't have steps anywhere, but you have to have reasonable alternatives to those that allow access. You can have a staircase and escalators in the lobby of this hotel. You better throw in some elevators as well. If you're going to have 22 stories, you don't just need those for the disabled folks, but nevertheless. And then 3, there are rules about new construction. Let me go into some more detail about all of that. Barriers have to be removed where that is readily achievable. That means little difficulty or expense in relation to the resources of the organization. That is often why historical buildings do not need to be gutted from scratch in order to satisfy the ADA. If it requires a huge amount of effort and resources compared to the organization, they don't need to remove a barrier. So if you have a local historical society and it's in the 300-year-old courthouse, they may be obligated to provide alternatives, but they may not be required to remove barriers. Or if they have a second floor and the only way up there is 20 stairs from back in the day, even though they're covered by the ADA, they may not have to remove those barriers. Providing alternatives to barrier removal, so if they cannot remove the barriers, then they need to provide reasonable alternatives. Again, that's going to come down to cost and to effort required. Leaning Tower of Pisa does not need to wrap itself in a ramp if it were in the United States, because that's probably not feasible. Nevertheless, if you have an older building and, hey, they've got room to put a wheelchair lift or a ramp on back and they have the means to do so, they probably are legally required to do that. Now, again, it is measured in light of the resources of the organization. So if for some reason you've got one Burger King in the old Victorian mansion, I don't care if it costs them $2 million to put in the elevator, they probably have to do it. If it is Sally Mae's Diner downtown, they may not have to. They're not going to bankrupt a small business, but if you have a larger entity, then they're going to be required to make more efforts. 3, new construction or renovations have to comply with ADA standards. So the federal government has standards about how steep can a ramp be, how wide does the bathroom stall have to be, all those kinds of things. If you are doing new construction or a renovation, you have to include accessibility within that. So if you're going to go ahead and gut and re-spruce your 1820 bed and breakfast from scratch, you probably do have to comply with ADA standards with anything new that you put in. So if you have an old building, look for when was the last time it was renovated, because that may make the difference as far as what they're obligated to do. Other limitations on Title III, though, like the government, they do not have to fundamentally alter the nature of their goods or services offered. So if you have, an example that I saw was, if you have a planetarium, they do not need to raise the lights in order for an ASL interpreter to stand in the middle of it and interpret what is going on. They may, though, have to provide a script and a small reading light for somebody who cannot hear the presentation. So I may not be able to get to the lowest level of the Grand Canyon, for instance, but they do have to provide something, right? I've been to museums where they will have an iPad and say, hey, we could not get the second floor to be accessible, but what we did do is a video walkthrough with information. We will have a tour guide stand with you and explain to you any questions you have. Is it a perfect equivalent? No. But is it some sort of accommodation? Yes. And if it prevents them from having to fundamentally alter what they're doing, they may be exempted. They also do not have to take any actions that undermine safe operation. So if some sort of accommodation could pose a threat to somebody's safety directly, then they're not required to do it. Anybody here ever get told a wheelchair is a fire hazard so we can't allow it in? If it is based solely on a stereotype, then that is probably not going to count as a threat to safety. Nevertheless, there are certain places where having oxygen tanks might actually pose a direct threat to safety. And so allowing those inside may not be an accommodation that's required. And then lastly, they're not required to undertake an undue burden, again, in light of the resources of the organization as a whole. So one artist who has a gallery 5 flights up a walk-up in New York City, they're probably not going to be required to do anything. If the Guggenheim buys it and turns it into a new gallery room, yeah, they probably have to start knocking out some walls. A fundamental alteration, I gave the planetarium example already. Safe operation. People with disabilities cannot be excluded unless there are legitimate safety reasons, not stereotypes based on actual risks. So to take our pontoon boat example, a 500-pound wheelchair riding along in a rubber plant pontoon boat, that might actually pose a safety risk that's direct and real, right? A direct threat means you can't eliminate the risk by, say, having somebody just mask up. So, hey, you're immunocompromised. If you come on a crowded bus tour, you might get sick. So we can't allow you. No, you could just require masking. That might not be considered an undue burden. That might be a required accommodation. Undue burdens would be significant difficulties or expenses, sometimes a challenging determination. That means lots and lots of money gets paid to lawyers to argue about what is undue burden in the accommodation context. It's case by case. Again, it's based on the overall financial impact on the whole company, not just me. Okay, so do we have to make the store, our 5th floor gallery accessible? You might not even buy anything. Doesn't matter. Okay, it doesn't matter that you're going to spend $5 at McDonald's on your breakfast. They still have to accommodate you if they can in light of what the company has as resources. Okay, that's our titles. I said that Title III's concepts of undue burdens and reasonable accommodations would have something to say about Title I with employment. A lot of these tools are what we look to as well. Do you fundamentally alter the nature of a person's job in order to accommodate them? Then no, that's not a required accommodation. Is it an undue burden? You have 3 employees. One of them cannot work after 3 o'clock in the afternoon, ever. That is probably an undue burden depending on the nature of the business. And so they're not required to accommodate that. Right? I need 10-minute breaks every 20 minutes. Okay, that is probably an undue burden in the employment context. Right? But if it is a matter of, look, we have 3,000 employees, somebody's working night shift anyway, you have a disability-based reason why you need to, they probably have to accommodate you. all of this trickles down into very specific things that come down to court decisions, that come down to what lawyers can tell you. Something I really should have said at the start, I am doing all of this as public education in a very broad context. I am not giving any of you, in any of the questions and answers, legal advice. I'm not telling you who to sue or who not to. I can try to give you a little more detailed advice, depending on your situation, or I may be able to try to help you find an attorney who can help more with detailed situations. Nevertheless, I can say what common sense sounds like it fits within the general things that the law says. Okay, does that all make sense? With that big warning in place, I'm going to take some questions and answers and talk through things. Yes, ma'am, right here in front. And I'm going to repeat questions so that our live streamers can hear them, and in case you can't hear in the back of the room.